Welcome to the Bankruptcy Court for the Northern District of West Virginia. We developed this video to help residents of this district understand some of the differences between a Chapter 7 and a Chapter 13 bankruptcy filing. In this video, we interview members of the public and bankruptcy professionals. Following those interviews, we provide a brief check sheet of 20 differences between the two chapters and a brief discussion of each difference.
If you are watching this video because you are considering filing a bankruptcy petition, you should know that bankruptcy can have serious, long-term financial and legal consequences. You should hire a lawyer to help you consider your options. Only a lawyer can give you legal advice about what can happen as a result of filing for bankruptcy. If you choose to file a bankruptcy petition, a lawyer can help you fill out the forms properly and represent your interests in the legal proceedings. The law allows you to represent yourself in bankruptcy court. However, many people find it difficult to successfully represent themselves. The law and rules regarding bankruptcy can be complicated, and a mistake or inaction may harm your interests. If you file without a lawyer, you are still responsible for knowing and following all the legal requirements. So consider carefully before filing for bankruptcy relief without the assistance of a lawyer.
For the first segment of the video, we asked individuals if they know what a bankruptcy filing is.
No, I don't have any experience doing it, so not sure.
Bankruptcy filing is when you got yourself in so much debt that you can't pay for it, and you have to file to see if you can't get out of debt by filing for bankruptcy.
Well, it's when accumulated debt exceeds what you actually have in assets.
I know that it's something people do or businesses do when they can't pay their bills. I know there are different types. I'm not real sure what the differences are in those types.
Just some basic information on it, not a great deal. I know when you're not financially able to handle your responsibilities for bill payments anymore, there is a legal way that it can help you with alleviate your debt.
We then asked individuals why they think people file bankruptcy.
I just have a general idea that it could be because your personal finances or your business finances, you ran out of money.
Bankruptcy.
Well, they file for bankruptcy because they got themselves in trouble. They can't, they bought boats and houses and now they can't afford to pay for them.
Well, sometimes things happen in life, sometimes with their own doing, sometimes against our own doing. Just sometimes we get, above us in debt sometimes, and we just have to find a way to get ourselves back to.
As far as individuals, I think they really don't get a good grip on their finances.
It could be loss of a job that makes it so hard that you can't survive anymore, and it's just a way you could handle your financial responsibilities.
The last question we asked was if these individuals knew one or more differences between a Chapter 7 and a Chapter 13 bankruptcy.
No, I do not.
That I really don't know.
I think some of it just depends on the amount of debt and the repayment plan.
I don't know what the differences are in the two types of bankruptcies.
Actually, I don't know a lot of the different filings itself.
We also interviewed Pat Cassidy, attorney, and asked what he does if he receives notice that an individual involved in a dispute files a bankruptcy petition.
Cry first, and generally what it means to us is that the case that we have designed and expect and contemplate, which moves through discovery and trial, and generally a verdict or not, but if you get a verdict, generally you can collect it. But when we hear that a defendant files for bankruptcy, we know that that whole progression is not going to happen.
Kelly Coder, attorney, discussed some of the common underlying causes of individual bankruptcy filing.
There's a variety of reasons why people come in to file bankruptcy. Sometimes there are people that are just not very good with money, that is, they can't control their spending. Most of the time it's individuals that have suffered some sort of issue in their life. They had a medical issue and they couldn't work, or they got hurt at work and weren't able to work, some sort of job loss that has caused an interruption in their income, and necessitated them to need to file bankruptcy.
Kelly Coder also discussed how she explains the differences between Chapter 7 and Chapter 13 to an individual that comes to her seeking debt relief assistance.
A Chapter 7 bankruptcy is the kind of bankruptcy that people, when they think of bankruptcy, that's usually what people file. It's usually over in a short, 4 to 6 month time period from the time you start until the time your case is over. A Chapter 7 is appropriate for most filers, but some people need to file a Chapter 13, which is generally kind of like a debt consolidation and repayment plan. Chapter 13 is also appropriate for individuals who are behind on a house or a vehicle and they want to retain those pieces of property. Occasionally, if you have debtors that have significant tax debt, a Chapter 13 would be a good option because it stops penalties and interest from accruing, so you can get a handle on your tax debt and get that paid off in a 3 to 5 year period. Similarly, if people make too much money to qualify for a 7, they could file a 13, or if they have too many assets that could be at risk if they filed a Chapter 7, then they could file a Chapter 13 as a better option.
We will now discuss Chapter 7 and Chapter 13 of bankruptcy.
Chapter 7 of the Bankruptcy Code. In a Chapter 7 case, an individual discloses all the individual's assets and liabilities on the schedules and statements accompanying the bankruptcy petition. These assets create a debtor's bankruptcy estate. Under applicable exemption statutes, a bankruptcy debtor may keep some or even all of this property to prevent destitution and to assist the debtor in obtaining a financial fresh start after bankruptcy. Primarily with regard to secured debts, a debtor declares his or her intention to surrender the property to the secured creditor, redeem the property, or execute a reaffirmation agreement and remain liable on the debt after entry of a bankruptcy discharge. Between 21 and 40 days after filing a Chapter 7 bankruptcy petition, a debtor appears at a meeting of creditors and answers questions from the Chapter 7 trustee. The trustee determines if there are any non-exempt assets to administer for the benefit of the debtor's creditors. If there are no assets to administer, the trustee informs the court of that fact, and about 60 days thereafter, the court will enter an order of discharge. Consequently, a typical no-asset Chapter 7 case will last about 100 days from start to finish.
Marty Sheehan, a Chapter 7 trustee, informed us about what to expect when filing a Chapter 7 petition and how to make a case successful.
The most important thing is to be truthful with the process, either with your attorney or with your, or if you filed your own, is to do it that way. The difficulty for a lot of people is that they don't know what we're asking, and questions are pretty simple. What do you own? Who are your creditors? Which of your assets have you pledged to some of your creditors as secured collateral? And how much of that property are you claiming is exempt? A lot of people don't understand exemptions or the concept behind them. They certainly don't understand the statute without the help of an attorney, in my experience. And so those are the kind of the walkthroughs I have for people trying to understand how the process works. The most important thing.
Marty Sheehan also informed us about what happens when an individual fails to disclose an asset to their case trustee.
We have a good bit of this, and mostly this arises in what I'm going to call assets that you don't think you have. When I ask you if you own any property, you might think of your house or your car or your furniture or your clothing. You tend not to think about your right to bring lawsuits, because even lawyers don't think about that generally as property. But those rights are in fact property. What happens is if you don't tell us about them in the beginning, your case doesn't get handled exactly right, and so you may end up losing out by failing to be forthright.
The failure to disclose your assets and or income in a bankruptcy case may subject you to criminal penalties. It is critically important that you accurately report all of your assets and income in a bankruptcy proceeding. The failure to do so may result in the loss of your discharge and or criminal prosecution. Chapter 13 of the Bankruptcy Code. In contrast to a liquidation of assets under Chapter 7, Chapter 13 allows an individual with regular income to adjust their debts and potentially keep their property that is subject to foreclosure or repossession, and which might otherwise be subject to a trustee's sale in Chapter 7. Typically, an individual in Chapter 13 is attempting to save a home, although there are many other reasons to consider Chapter 13. In a Chapter 13 case, an individual proposes a repayment plan that lasts up to 5 years. The Chapter 13 trustee and creditors have an opportunity to object to the proposed treatment of debts in the debtor's Chapter 13 plan, and it is subject to a confirmation hearing in front of a bankruptcy judge.
Helen Morris, the Chapter 13 trustee, explained what a Chapter 13 bankruptcy filing is.
The Chapter 13 case is an opportunity for a debtor to formulate a plan that fits his or her lifestyle so that they can go forward. They create a budget based on what's important to them. Now, certain changes will have to be made, otherwise they wouldn't need the bankrupt filing. But the Chapter 13 case is an individual efforts to repay debt, get back on financial track. It's not a cookie cutter, even though there is a form plan. Each person can make this plan work for him or herself.
Helen Morris also discussed why an individual should contemplate a Chapter 13 case instead of a Chapter 7 case.
I think Chapter 13 is the best chapter of all the chapters in bankruptcy. It is a way that the debtors can level the playing field with their creditors. For example, in a Chapter 13 case, a debtor can formulate a plan that repays an arrearage on a mortgage. In a Chapter 7 case, the creditor is in control. If the creditor wants to allow debtors to do something to correct or cure the arrearage, it's still in the creditor's hands. In a Chapter 13 case, the debtor can propose a plan that, if it's reasonable, the judge can approve that allows the debtors to cure that arrearage over the life of the plan, which could be as long as 60 months, rather than a 6-month period that the creditor may assign to it. Debtors can change the interest rate. They can change a 20%, 19% interest rate on a vehicle to a 6% interest rate in the Chapter 13 case. Tax liability is another problem that debtors can take care of in a Chapter 13 case that they can't take care of in a Chapter 7 case. In the 13, they can propose to pay a priority tax claim over the life of the plan. If they complete the plan, then they don't owe anything else on this priority claim. In a Chapter 7 case, the case is over. The IRS or the state tax department is there waiting to collect not only the principal owed, but the interest that is accrued.
Now let's look at 20 specific differences between Chapter 7 and a Chapter 13. To help us through this checklist, we have asked for the help of multiple bankruptcy professionals.
Our first consideration is whether or not an individual has the ability to make payments under a Chapter 13
In a Chapter
plan.
13, a debtor is required to make a monthly payment for the next 3 to 5 years. If the debtor doesn't have enough disposable income to fund the plan is not feasible.
Chapter 13 offers a super discharge. What does that mean?
The Chapter 13 discharge is much like the Chapter 7 discharge, except it is broader to include discharge of debts for willful malicious injury, fine, penalties, or forfeitures payable to a governmental unit, and for certain debts that arise from a divorce obligation that do not constitute a domestic support obligation.
The last two of those obligations are not dischargeable in a Chapter 7 case. It's important to note that with the issue of a willful and malicious injury, the bankruptcy rules set time limits for a creditor to raise that issue. If a creditor does not raise that issue timely, it is possible in a Chapter 7 case for that debt to be discharged.
How does the Chapter 7 discharge injunction and the automatic stay in a Chapter 13 case impact the choice of
Chapter
chapters?
13, there's a plan that runs from 3 to 5 years, and the stay is in place for 3 to 5 years. Also, you'd have to get relief from stay from the court if a creditor wants to take any action during that period of time to foreclose or to repossess their collateral.
Well, first of all, an automatic stay is something that happens the minute that a case is filed. Eventually, you'll get a discharge. The problem is there's debts that aren't dischargeable in Chapter 7 as an example. So what's going to happen is as soon as you get the discharge in Chapter 7, which might happen as early as 90 days after you filed the case, then they're going to be able to start collecting the debt again, like student loans or whatever. An automatic stay, that period between the time you file the case and the discharge is granted, in a Chapter 13 is going to be going from 3 to 5 years. So
Now you can only obtain a bankruptcy discharge every so often. How does that impact the choice of filing?
Generally, if you are filing a Chapter 7 case and want a discharge, you cannot have obtained a discharge in a previous Chapter 7 case within the last 8 years, or obtained a discharge in a Chapter 13 case in the past 6 years. Think about your eligibility for a discharge now and about your need for one in the future.
To obtain a discharge under Chapter 13, you cannot have obtained a discharge under Chapter 7 within the preceding 4 years.
Why is Chapter 13 the best chapter for keeping property?
Chapter 13 is the best chapter for keeping property because Chapter 13 allows debtors to work with their creditors to pay, for example, mortgage arrearages over the life of the plan, as opposed to a shorter period of time. It allows debtors to retain vehicles and change the interest rate to make it a more manageable payment.
Chapter 7 works for individuals who no longer want to retain their secured property. However, they can still file a reaffirmation agreement and be personally responsible for the debt after the discharge is entered.
Equity is the value of property minus the amount owed. How does the amount of equity influence the choice between Chapter 7 and Chapter 13?
Yes, when you're filing bankruptcy and you own a vehicle, you look at how much the vehicle's worth minus how much is owed on it to see what the equity is. In a Chapter 7, you're allowed an exemption of so many dollars. So you look at that as to whether you want to file a Chapter 7 or Chapter 13, just looking at how much the equity is. If there's a substantial amount of equity that you may lose the vehicle to the trustee in a Chapter 7, then you may want to look at a Chapter 13 where you get to keep all your assets as long as you make payments to the trustee over a 3 to 5 year period.
Chapter 13 helps those debtors who have equity in property in excess of an exemption. Looking at an example is helpful.
This is our district's form liquidation analysis that is attached to our model Chapter 13 plan. Remember, this is just an estimation. As shown, however, the property has a value of $200,000, a secured lien in the amount of $100,000, and the claimed exemption in this case is $25,800. Allowing for reasonable costs of sale, this individual has $54,200 in non-exempt equity. In a Chapter 7 case, we must allow the trustee to receive a statutory commission, and this means that we can estimate that $48,240 would be available to creditors had this person filed a Chapter 7 case. In Chapter 13, this individual may keep the property if the individual proposes a plan to pay unsecured creditors at least $48,240.
When a person files a bankruptcy petition, a bankruptcy estate is created consisting of all the individual's property. Who controls that property?
The Chapter 7 trustee controls the property, but a debtor may keep property that is exempt.
In a Chapter 13 case, the individual controls the property of the estate. In some instances, though, that control is subject to the supervision by the Chapter 13 trustee and by the court.
Which chapter is better for a debtor with tax debts?
Chapter 13 is the best chapter for debtors with tax liability. If a debtor has priority tax liability, then it can be paid over the life of the plan in full, the principal amount, no penalty, no interest, and at the end of the completion of the case, the debtor has a discharge for the remaining penalty and interest. It can't be charged. In a Chapter 7 case, once the case is over, the taxing authority is looking for principal plus interest plus penalty.
Sometimes people have tax debts. These are often non-dischargeable in a Chapter 7 case. Nonetheless, we will sometimes file a Chapter 7 case first and have our client get a discharge. That will discharge all the debt except the tax debts that are non-dischargeable in the Chapter 7 case. We'll then file a second Chapter 13 case very quickly, and the purpose of that 13 is to pay the taxes out over time. The advantage of filing the 13 is that the automatic stay kicks in, and IRS is limited in what kinds of collection activity it can take during that time. The other more important reason is it stops the running of interest on the money that you owe, so you're paying at the lowest possible amount that you have to pay. This process of filing a Chapter 7, followed by Chapter 13, is unofficially called by lawyers filing a Chapter 20 case.
Say someone's mother co-signed a car loan for a child. If the child files bankruptcy, what happens to the mother?
The mother is liable on the note, and the car creditor can seek payment from her.
In Chapter 13, however, the mother is protected by what's called the co-debtor stay, and the creditor cannot recover from the mother without seeking relief from the stay from the court. If the child, for instance, proposes to pay the creditor in the Chapter 13 plan, for instance, then the creditor will likely be unable to recover from the mother.
Many people have second mortgages on their home. How does this impact a choice between Chapter 7 and Chapter 13?
This impacts the decision between Chapter 7 and Chapter 13 because Chapter 13 provides additional relief to debtors in this situation. For instance, if the debtor's home is fully encumbered by a first deed of trust and is subsequently encumbered by a second deed of trust beyond the value of the home, Chapter 13 affords debtors the ability to strip the wholly unsecured deed of trust in Chapter 13.
This type of relief is not currently available in Chapter 7. All liens stay with the property after discharge regardless of the property's value.
What is the difference in attorney's fees between a Chapter 7 and a 13?
Virtually all of the attorney's fees have to be collected prior to the filing of the petition. Otherwise, those fees are subject to discharge just like any other debt.
In a Chapter 13, there's a lot more work involved, and the attorney fees are substantially more than in a Chapter 7. So a lot of the fees are put into the plan and are paid over the 3 to 5 year plan out of the amount the debtor pays to the trustee.
To be paid from a bankruptcy estate, creditors file proofs of claim. What does that mean in Chapter 7 and Chapter 13?
Well, in a Chapter 7 case, most Chapter 7 cases, at least in this district, are no asset cases, and generally all cases go out on notice that there are no assets. But if a trustee discovers assets, he's going to send out a notice to file a proof of claim, and if a creditor is owed money, they have to file this form with the bankruptcy court, and if they don't, they won't get paid. So consequently, they may be owed money, there may be assets, and they could get paid all or part of their debt, but by their failure to do so, then they don't get paid at all and their debt's discharged.
In order for creditors to receive payment through a Chapter 13, they need to file a claim. Those claims are often monitored for the validity and the amount. The claims are reviewed to make sure there's no personal information that shouldn't be there, reviewed to make sure that the amount claimed that is owed is actually owed, and also the claims are reviewed to see if they are secured or unsecured or priority debts.
Now, if a debtor has student loans, is it better to use Chapter 7 or Chapter 13?
Assuming that student loans are not dischargeable, and for the most part they will not be, filing Chapter 7 avoids many of the pitfalls in treatment that would be required in a Chapter 13 plan.
3 basic options for a debtor who has student loan liability. If the debtor is current on the student loans, then just continue to make those payments directly. If the debtor is not current on student loans, then the debtor has a couple of options within the Chapter 13 case. The debtor can carve out a portion of the student loan to be paid through the Chapter 13 plan, or the debtor can include those student loan debts as part of the payments to unsecured creditors. At the end of the case, however, the debtor will still owe student loan claims, and interest will continue to accrue over the life of the plan.
For a motor vehicle, what is the difference between a Chapter 13 cram down and a Chapter 7 redemption?
In a Chapter 13, vehicle loans can be paid at a preferred rate of interest. And if a vehicle loan is older than about 2.5 years, you can also pay the value of the vehicle as opposed to what is owed on the loan at that interest rate. This is commonly known as a cram down.
Chapter 7 case, you're really left with, when you have a secured debt, either paying that debt or surrendering it. Now there's some question about under what circumstances you can keep that. Normally we're talking about a motor vehicle, but one method of doing that is by redemption. In other words, you can buy it for what it's worth as long as it's a family household use item. So that's done by motion and affidavit, and then if there's no objections, then you can buy it for the value. If there's some objection, then there has to be a hearing on it.
Why might a debtor with a short-term loan at a high interest rate consider filing Chapter 13?
Consider a debtor with an unusually high interest rate of 19% on a car loan that lasts the next 4 years. In Chapter 13, the debtor may be able to extend that repayment period over the life of the plan, which may be as much as 5 years, and modify the interest rate to the bankruptcy rate, which varies but is well below the 19%.
If a person wants to keep that car, Chapter 7 won't lower the contractual interest rate. A Chapter 7 debtor may surrender the vehicle and look for a better option.
When a person promises to pay a debt, that is a meaningful event. What about a person's moral obligation to keep their
The
promise?
decision to file a bankruptcy petition involves many complex and serious issues. For many people who file bankruptcy, there's more involved than a simple decision to break a promise to repay. For those people who find themselves in a situation where they're unable to repay, but they feel a compunction to make some repayment if possible, Chapter 13 is for them what they consider to be a more moral option, allowing them to make their best effort at repaying while still allowing them the relief to keep themselves and their family afloat in difficult financial circumstances. This does involve them laboring under the supervision of the trustee and the court. It's not an obligation to be undertaken lightly, but it is one that's to be applauded if they are able to complete it.
I think that morality is a much bigger issue than choosing between a Chapter 7 or a Chapter 13 bankruptcy petition. Few, if any, debtors actually like to be in bankruptcy court. Bankruptcy court does offer a financial fresh start in life that's free from the fetters of pre-petition debt. However, a bankruptcy petition is accompanied by a lot of debate, consternation, and stress. When Chapter 7 is the right filing chapter based upon an individual's circumstances, and if that individual feels a moral or natural obligation to repay what they can to pre-petition creditors, once the bankruptcy discharge is entered, nothing prevents that individual from voluntarily making payments to pre-petition creditors. The difference is that it's the debtor's choice. It's not the court, not the Chapter 13 trustee, and it's not the creditor.
What is means testing, and how does it affect the choice of chapters?
The means test is a bankruptcy form that is required to be completed by consumer debtors in a Chapter 7 bankruptcy case. The purpose of the means test is to determine your eligibility for filing Chapter 7. And the form collects information for the debtor's income and expenses for the prior period of 6 months before the petition is filed. If a presumption of abuse arises based on the form, the debtor's case may be subject to dismissal and/or debtor required to present special circumstances in order to avoid dismissal of the case.
Means testing does not exist in Chapter 13. Chapter 13 debtors, however, have a similar test to determine disposable income. That test is used to ensure that debtors pay creditors what they can afford.
There are maximum debt limits for a Chapter 13 case. If a person exceeds those debt limits, is Chapter 13 an option?
If a debtor files Chapter 13 but exceeds the statutory unsecured and secured debt limits, which change from time to time, a motion to dismiss may be filed. In that event, conversion to another chapter, perhaps Chapter 11, is necessary.
There are no debt limits for an individual filing Chapter 7.
If a debtor is having difficulty with a mortgage servicer, why is Chapter 13 better than Chapter 7?
If a debtor is having trouble with a mortgage servicer, Chapter 13 is an excellent tool to be able to deal with that creditor. The plan can provide that the trustee makes the ongoing payments, and that the arrearage is cured over the life of the plan. The Chapter 13 trustee then has a record of payments were made to the mortgage creditor, and Chapter 13 is a vehicle through which the debtor can review the trustee website, see how payments are being made, and keep track of this. Plus, the code requires a mortgage company to apply the payments pursuant to the confirmed plan. If the debtor is making mortgage payments through the trustee, at the end of the case, the trustee files a motion or a notice of final cure, and there is a 21-day period for which the creditor can respond and say the debt has not been paid. If the debt is cured, there's an order entered that says that the debtor is current on the mortgage payment, and it goes forward the debtor goes forward to make the payments themselves. Otherwise, there's a hearing in which the creditor has to prove that there are still a balance due on the pre-petition arrearage or the ongoing mortgage payments that were made through the trustee. There are restrictions on the creditor being able to collect funds that they did not raise at this point.
If a person does not like to disclose or have supervision and review of major life events, what would you tell them?
In Chapter 13, a person is allowed to retain and use their property while repaying what they can to creditors. During this time, a debtor is required to file and disclose their tax returns, report any significant changes to their income, and some life changes like selling a home require prior court approval.
Both a Chapter 13 case and a Chapter 7 case are public records. It's a little bit like being in a fishbowl. In a Chapter 7 case, though, it's more like a snapshot is taken in time, while in the Chapter 13 case, it's more like a video that extends over a period of time.
Well, that's it. That's our video overview on 20 differences between a Chapter 7 and a Chapter 13 bankruptcy petition. Of course, there are far more differences than 20. And of the ones we mentioned, well, they're based on general principles, and applying those principles to the facts of any particular case can be much more complicated and nuanced. At the very least, we hope that we have convinced you to at least consult with an attorney before filing a bankruptcy petition.
Thank you for watching. We hope you understand some of the differences between Chapter 7 and Chapter 13, but if you do not, that is okay. As you can see, you are not alone.